Hey everyone, I'm James from the Drafting Studio, and today we're talking about cure periods, those critical windows of time that can save your deals from falling apart over fixable problems. Think of it as the let's talk about this before someone storms off clause of contract law. If you're a founder handling your own contracts or a junior lawyer drafting for the first time, this 5-minute tutorial is going to show you exactly how to write a well-written cure period provision that actually protects your interests. Now, before we start, this content is educational only and not legal advice for your specific situation. Watching this video does not create an attorney-client relationship, and so for personalized guidance, you need to consult an attorney. Now, let's dive in. Here's a scenario. You're negotiating a services agreement and the other side wants the right to terminate immediately if you breach. That's a problem, because what if the breach is something minor, like being a day late with a monthly report? Here's the thing, without a cure period, you could lose a major contract over something that is totally fixable. It's like breaking up with someone because they forgot to text back one time. It seems a bit extreme, right? So that is where cure periods come in. They give you a reasonable time period to fix the problem before the other party can pull the plug. But here's what most people get wrong. They either make the cure period too vague to enforce, or they accidentally create loopholes that defeat the whole purpose. And then everyone ends up in a conference room arguing whether reasonable efforts were made, for example. Here's a basic structure of a solid cure period provision. Let me get this to you. The non-breaching party may terminate this agreement if the other party materially breaches any provision, provided that the non-breaching party first provides written notice specifying the breach and the breaching party fails to cure such breach within 30 days after receiving such notice. Let's break down why this works. First of all, notice that it says materially breaches, not just any breach. This prevents termination over trivial issues because, yes, being 5 minutes late to a kickoff call is technically a breach, but no, it shouldn't end your relationship and shouldn't be the basis for terminating a contract. Second, it requires written notice, no surprise terminations, no I sent you psychic signals that I was unhappy. The breaching party must know specifically what they did wrong. Third, it specifies what the notice must contain, the specific breach. This isn't optional. Vague notices like you're not meeting expectations should not trigger the cure period. Fourth, 30 days from receipt of notice, not from the breach itself. The clock starts when you actually know there's a problem because playing gotcha with breach dates is nobody's idea of a good time. Now, let's level this up with 3 critical additions that separate the amateurs from the pros. Addition number 1, let's carve out uncurable breaches. We might add language like this: except that no cure period shall actually apply to breaches that cannot reasonably be cured, including but not limited to unauthorized disclosure of confidential information or breaches of payment obligations. Why would we do something like this? Because some breaches simply cannot be fixed. If someone leaks your confidential information, a cure period is meaningless. The cat's already out of the bag. Good luck getting it back in. Same thing with payment breaches. You don't want someone to be 90 days late and then claim they're curing the breach by finally paying. That's not cure, that's just eventually doing what they should have done in the first place. Addition number 2, specify the cure standard. You might add something like, a breach shall be deemed cured when the breaching party has taken all actions necessary to remedy the breach and prevent its recurrence. This prevents someone from doing the bare minimum and claiming that they've cured. Sure, I stopped the bad behavior temporarily until next week. That's not cure, that's a pause button. Addition number 3, handling repeated breaches. You may add something like, if the same breach occurs more than twice in any 12-month period, the non-breaching party may terminate immediately without providing an additional cure period. This prevents someone from breaching, curing, breaching again, curing again indefinitely. Because at some point, oops, my bad stops being convincing. 3 strikes and you're out. This isn't baseball, but the principle still works. So here's what a complete provision might look like if you put all of those extra pieces together. Here we go. Either party may terminate this agreement if the other party materially breaches any provision hereof, provided that the non-breaching party first provides written notice specifying the breach in reasonable detail and the breaching party fails to cure such breach within 30 days after receiving such notice. A breach shall be deemed cured when the breaching party has taken all actions necessary to remedy the breach and prevent its recurrence. No cure period shall apply to breaches that cannot reasonably be cured, including but not limited to unauthorized disclosure of confidential information or breaches of payment obligations. If the same breach occurs more than twice in any 12-month period, the non-breaching party may terminate immediately without providing an additional cure period. A pro tip for negotiation. Cure periods are usually mutual provisions. Both parties benefit from having time to fix problems. So if the other side pushes back, remind them that they might want this same protection when they inevitably forget to send you that quarterly report on time. We're all human, we all make minor mistakes here and there. The time period is negotiable. I've seen everything from 10 days to 60 days. 30 days is the most common middle ground, which is convenient because it's also about how long it takes most people to actually get around to fixing things anyway. Your industry may require a shorter or longer period. But that's how you draft a cure period that actually works. Include these elements, and you should find yourself with reasonable protection against overreaction while still maintaining the ability to exit truly problematic relationships. If you found this helpful, subscribe for more contract drafting tutorials. And if you want to dive deeper into non-disclosure agreements specifically, I've put together a free 20-minute mini class that walks you through everything you need to know about reviewing and negotiating NDAs. You'll get a walkthrough of an NDA, my complete NDA review checklist, and learn the exact framework that I use with my startup clients. Click the link in the description to grab that free training. I'm James from the Drafting Studio. Thanks for watching, and may all your breaches be curable.